Hello and welcome to another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego. I'm Bud Kluick, founding and managing partner of Family Law San Diego. The topic of today's video is fault. We often hear that California is a no-fault state. What does that mean and what doesn't that mean? California for a long time had contested fault divorce, where the judge would find that one of the two spouses was at fault. But it hasn't been that way for a long time, since January 1st, 1970, more than 50 years. In the old days, if you proved fault, you would get more than half of the community property, rather than just splitting it 50-50. People still use the old term contested or uncontested divorce, but it doesn't really mean anything. It's not a thing anymore, because you ultimately cannot contest a divorce anymore. If one of the two parties is willing to say under oath that irreconcilable differences have arisen in the marriage, the divorce will go forward. You can't contest a divorce, but there are ways in which fault becomes an issue. The first, of course, is domestic violence. With domestic violence, clearly, you are asking the judge to find that the other person was at fault and committed domestic violence. A finding of domestic violence affects the person and their legal rights in numerous ways. To begin with, it affects child custody. Section 3044 of the Family Code says that if you are found to have committed domestic violence within the last 5 years, there is presumption that you shouldn't have physical or legal custody of your children. It's a rebuttable presumption. You may be able to overcome it, but that's a presumption. You can have custody. Also, having a restraining order regarding domestic violence takes away from the perpetrator several constitutional rights. It impacts the right of free speech. They can't talk or contact that person, the protected party or parties. It takes away the right of free assembly. They can't assemble with that person or come within 100 yards of them. And it takes away their right to bear arms. They have to surrender all of their guns. When California did away with fault divorce, they thought it was better to concentrate on the big issues of children and money, finances. In other words, there's plenty to fight over about dividing up the marital estate or how the children are going to be shared and raised. For example, involving money, if one of the parties is using community property to buy their new significant others fancy jewelry or take them on a trip to Europe, that's not the use of community property money, and they may have to reimburse the community for what they spent, and in that sense a judge would find fault. Similarly, if you are not behaving properly with your children, fault can be found and it impacts your access to your children. We've already discussed that domestic violence does, but just if you're angry with your children and behaving inappropriately. If you have any further questions about fault or no fault or any other questions involving California divorce or legal separation, please contact us at Family Law San Diego. Our phone number is 619-448-6500. Listed another way, that's area 619-448-6500. Or visit us on the web at www.familylawsandiego.com. That's www.familylawsandiego.com. One word, Family Law San Diego, no breaks, no dashes, no dots. Thank you for watching another video in our video series, 3 Minutes of California Family Law, brought to you by Family Law San Diego.